So this is our ninth lecture in our series. Basically, learners from across the community and across professions, really. So we've got some in healthcare and a lot of community based people, some are healthcare, some are more in the social sector. So very wide variety of learners here. This is our week 9, like I said, of our lectures, and basically trying to span the scope of important geriatric issues, starting with healthy aging through end of life. So today, learners, we have the pleasure of having Sylvia Pla-Raith, so I do have her pronunciation right now, doing a lecture today on guardianship, surrogate decision makers, and elder abuse. So she's with the Elder Justice Unit with the Ohio Attorney General's office. So she is definitely an expert in this area. So as we talked before, if you have questions as you go, I'm going to monitor the chat. And we'll try to, insert if it, or we'll hold off if it seems like it could hold on to the end. So I'm going to turn it over to you, Sylvia.
Well, thank you, Sue. There is already a chat, so maybe it's just someone saying good morning.
It was.
Or good afternoon. I think it's afternoon now.
It is.
So I thank you for inviting me. So and thank you for calling me an expert. Well, I like to consider myself a lifelong learner, and I'm still learning a lot about older adults, and I'm not sure I'm ready to say expert yet, but for those of you who don't know me, I've been at the Attorney General's office now for about 7 years, and the Elder Justice Unit is a resource that you might be able to use in the future if you have a case. So we do take calls from the public, and sometimes it's family members that are looking for some assistance. Ohio has a very fragmented elder justice system. Our systems don't connect very well, and sometimes victims are left behind. So the main reason that the Attorney General created our unit was to help redirect callers either to the appropriate organization or unit within our office. So I make a lot of referrals within our office. But I also find myself liaison very closely a lot with the local municipalities, Adult Protective Services, probate court. So this talk that I'm doing today, I'm actually bringing it to you from a couple different perspectives. So for the first 20 years of my professional career, I was a mandated reporter. I worked in Benjamin Rose, and I worked at Passport. So I was pretty good at assessing elders and their needs and connecting them to resources. Then I became the chief of Adult Protective Services in Cuyahoga County, and I did that for 10 years, which is where I believe I learned a lot about elder abuse and how that works. When APS can help someone when they can't. And then lastly, from a personal perspective, I became my parents' surrogate. I was my parents' power of attorney, and at the end made a lot of decisions for them as needed. And I served as my brother's guardian when he became very ill. So I feel like I put this together from all those different perspectives. So I'm not sure if I'm an expert, but I do feel like I feel comfortable talking about this because of that. But if you have a question and you want to jump in, I mean, that's why we have the chat, and we want to make this interactive. So we are going to be talking about, because we are talking about competency and guardianship, obviously we're going to look at incapacity versus incompetency. We're going to talk a little bit about some of the elements of surrogate decision making and what are the benefits. And I'll end up reviewing with you a little bit about Adult Protective Services and mandatory reporting as a review, because it's an hour long. And so obviously we're going to kind of do a look from a bird's eye view. So I always like to start with this one, because people in America, every country's different, but in America, once you reach this age 18, it's presumed, regardless of whether you have a disability or mental illness, it's presumed that you have capacity. And the reason I like to remind everyone of this, because I hear sometimes people say, oh, they're incompetent or they're this. And it's like, well, technically everyone is competent and everyone has capacity unless we know differently. And that's important, because when you're making referrals, especially with Adult Protective Services, and sometimes they're going to even ask you that at screen, unless you know this person's been adjudicated, you really have to say they're competent, but you may respond by saying, well, they might be competent, but I'm having questioning their capacity because they are making bad decisions and they're putting themselves at risk. So but here in America, we do believe, and this is important because we all have rights. One of the things you might hear when you are making a report, sometimes you hear people have the right to make bad choices. So, and that's true, but one of the things I want to remind you of is where it might become adult protective services, or there's typically what you want to focus on when you're making a report is, because of the bad decision, what kind of risk is it posing the individual? I want you to focus on the risk and how you think they might get hurt. Because if they counter back to you and say, hey, that, you know, they're adults, they have the right, you could say, well, I'm concerned about how this is going to impact their ability to care for themselves, their ability to be safe. That's just a little tip for you, because sometimes adult protective services will ask that question and might screen a case out. So with that in mind, I kind of want to see if you guys, if I'm talking to the choir, or is this a situation where you guys are going to be learning stuff? But do you think, using the chat, do you think that the terms of competency and capacity are similar concept? Do you think this is true or false?
And you can unmute if you want and just throw it out there.
Yeah, we have a small group.
False, false, false,
False, false, false.
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 So I'm talking to the choir. I can stop talking now. We can all go home. This is often missed by a lot of young professionals and people who are doing the work. And that's why I like to have the question that they think this is a similar concept. And it was one of my attorney friends, Judge Swift, as a matter of fact, who's retired from Trumbull County. He taught me the term that capacity and competency are kissing cousins, because they're connected, but they're not the same. And one of the things that I remind folks, especially when we're looking at adult protective services and whether or not we go for a court order, is a competent person can be incapacitated. And that's important because when APS does look at court orders and potentially puts APS as a surrogate, we've had enough proof to show the person was incapacitated. And I have to remind people of that all the time, because they don't realize, but if, and I know some of you know that medication, infections, there's all kinds of situations or complications that can render a competent person incapacitated and unable to make decisions. So they're not the same, and they're very different. And the thing about capacity, it's important because this happens too. Somebody can have the capacity to get dressed in the morning and make some decisions and even pay some of their routine bills, but they may not have the capacity to manage their complicated financial matters. So sometimes I see people will like, well, they have capacity, and I find myself asking, what do you believe they have capacity for, and what's the problem? So if I'm being financially exploited, for instance, I'm going to want to know more about their ability to manage their finances and even complex financial matters. So maybe they can pay their rent on time every month, but here comes along a scammer who's trying to sell them some fake stocks or fake something. They may not have the ability to understand the complexities that goes along with that contract. So it's important that we match up. If somebody's having trouble in an area, we kind of match up where we think the issues might be. Because if we're going to be asking an expert to do an evaluation, it'll be helpful for them to know what areas we have concerns about. And I'll give you an example real quick. I had a veteran that I was working with, and the facility was concerned because some of his finances were being mismanaged by his son. Initially, they wanted the judge to rule on his capacity of, they wanted to rule him incompetent. But the evaluation showed that he was actually able to manage his personal affairs. What he actually needed was simply someone to help manage his finances. And the reason that case got tricky was that in Ohio, for the probate court to consider for you to have an assets, you have to have assets over $25,000. He did not have $25,000. So what ended up happening for him was he had a limited guardianship that allowed him to make his decisions of person, but the guardian then was restricted to around financial decisions. So it's important to really match up where the issues are and because you want to try to maintain and reserve as much autonomy as possible. Matter of fact, the phrase I've been hearing more and more about is supported decision making, is because you're looking at trying to build off their strengths and then support their inabilities. So when we're dealing with and this is a big thing, is understanding informed consent, because when you're working with adults, informed consent requires that the person has capacity to understand and manipulate information. So if somebody is actually incapacitated in any way, they can actually undermine their ability to make an informed decision. So some of you already probably do this when you're talking to your adults about decisions, whether it be medical care or something, that before the doctor, for instance, does surgery, they typically review and make sure, do you understand the risk? They're basically trying to figure out if this person has the ability to understand, to formulate an informed consent. If not, we have to look towards an alternate decision maker. Self-determination is a tricky one, and I hear over and over again, and adults have the right to self-determine. And I see a lot of chat questions. So I'm assuming we're doing good, or they're not. You want me to?
No, those were for our previous. There's no new ones.
Okay, thanks.
I have a new one. Could I ask a question, please?
Sure.
This is Terry. So, like, competence means that you're able to make your own decisions, but capacity means you might make very poor decisions. Is that what you mean?
No, competent, and we'll talk more about it. Competency is actually a legal determination.
Yeah, that's what I was wondering. Could you define those legally, please?
So legally, competent in America, every adult age 18 and over, whether they have any mental illness or disability, is considered competent.
Okay.
And it's assumed. So you basically, if you're going to question that, it's typically requires a court hearing in front of a judge that reviews evidence, and one of the evidence that's typically presented is of a doctor's statement indicating someone needs a guardian, but it's actually a court ruling that the judge will determine based on the evidence presented. The adult has the right to be present. They can testify on their own, and sometimes the judge may decide the person is not incompetent, even if there's a statement from a physician. Or they might agree. But so it's a legal determination made in the courtroom with a probate court judge or magistrate who's had a hearing, who makes a decision if someone is no longer competent. Because
but what's the definition of the word competent in terms of legal?
Well, we'll probably get to the definition.
Okay.
If you need to see it in a slide, but
okay.
The definition, though, it's a legal, in the ORC, it's a legal definition, and we're going to get to it.
Okay, cool. Thank you.
The self-determination requires it, though. So when you're working with your adults and you're asking them what do they wish, so one of the things to keep in mind, for me to be able to self-determine and make a decision about myself, it assumes that I am perfectly capable of making those decisions. If I have any type of limitation where the adult either lacks capacity, that negates self-determination. So does undue influence, which you'll see this in elder abuse cases all the time, where the adult makes a decision based on information that was orchestrated by the perpetrator. I had a very severe case of undue influence, for instance, where the person was not allowed to access the telephone, was not allowed to access TV or newspaper. All the facts that they were dealing with in terms of making decisions were solely based on what the perpetrator wanted them to have. So on the surface, it appeared consensual and it appeared like they were making their own decisions. As a matter of fact, if you ask them, they would probably tell you they'd made the decision on their own, because they didn't. Most people who are unduly influenced don't even realize how they're being manipulated by their perpetrator. But one of the things I do when someone's consenting and they gave it's who's benefiting from that relationship. But one of the things that we talk about is if it appears consensual on the surface, it's like peel back the onion to find out how, under what circumstances did they consent? Because that's where you find out what really was the person making the decision by themselves, or they were influenced in any way by someone else, or they were lied to. Because in Ohio, we do have theft by deception, where sometimes people agree to an activity, but it was because they were lied to. They thought the money was going to go towards helping the granddaughter to go to college, but instead the father used the money to buy a truck. So he asked the individual, if you knew this money was going to go to buy a truck, would you have given him the money? No. So this is where it was consent because of they were lied to. So before you use that someone's self-determined, I just want you to point a couple things. Make sure that you're basing it on their value system and not yours, because many of you believe in self-determination and rights, but what does your adult believe and what is their value system? And remember, none of us really self-determine. Every day we have to balance what we want with the laws that are expected of us. You know, the traffic light turns red, so we stop. Why? Because, well, if I don't stop, I might cause an accident, or I might get a ticket, or you follow the speeding limit. Why? Because if I don't follow the speed limit, I might get a ticket. So you make decisions not only on your own value system, but you encompasses what's expected from you and what other people expect from you. So here's your slide that I want you to remember, because legal consent is not valid. And this happens quite a bit with elder adults. They make decisions because sometimes they're flat out lied to. Sometimes there's forced. I don't know how many folks, when you talk to them, you find out they agree because somebody, threatened them that they might put them in a nursing home or take away some of their rights or not allow them to see their kids. Or if they have pets, they take that away from them. So they cooperate because they've been coerced. So, or they're manipulated. All those factors could be challenged in court, in a legal court, because if the decision was made on a distress or if the person was lied to, it could be challenged that the consent was invalid. And again, I'm reminding you, if capacity is an issue or if they're unduly influenced, it could be challenged. So when do we question this? Because, I just told you adults have the right to make bad choices. And sometimes we have value systems. And I remember when I was a young social worker, people would tell me, before you go make a home visit, you leave your value systems at the door. And so you want to be as objective as you can when you walk in, or I wouldn't make these decisions. I wouldn't live like this. I'm going to challenge you a little bit, because all those are true. But I also want you to kind of, if those decisions, and this is where it's important even when you're making a referral to APS, if the decisions they're making are placing them in any kind of risk where they're not safe, they're being financially exploited, it's not stopping, or they're not eating like they're supposed to, they're being evicted from their house because the rent's not being paid because someone's taken the money. If the decisions they're making leads to some very poor outcome for them, that's what you want to focus on. And that's typically, for me, with my background in adult protective services and even Attorney General's office, if there's badness going on, and no one has evaluated this person, there's a certain point that I start asking questions. Have they been evaluated? Do we know what's going on? Are they making this decision because this is their lifestyle? Or are they making this decision because there's something going on? There's some kind of decline. And that's important because you don't always see it. One of the things I've learned in my career, sometimes it's really obvious because you can tell that you went to make a second visit. They can't remember who you are, but a lot of times it's not so much. These people sometimes can be very tricky when they have their social skills and they can talk to you and they have a conversation with you. You wouldn't know that there's something wrong unless you see them multiple times, or you wouldn't know if they're confabulating and they have a conversation with you and they made the whole thing up, but it was believable. So I typically tell folks, I start asking these questions when I see there's a problem. We tried to stop the problem, but it's still occurring and it's posing a threat to the individual. I do start asking those questions about, well, have they been evaluated? Because maybe there's something going on. So when I was with APS, I would tell my staff, our job wasn't to diagnose capacity or competency. My job was to get them to question it. When should we be screening it in as a problem, and when should we be, getting them evaluated and asking for an expert's opinion was typically what I was teaching my staff, because telling me someone has capacity or competency doesn't do me any good when I already know it's assumed. I already know that. So I'm going to start questioning it when I'm seeing some of this stuff going on. It's usually, again, tied to risk. So this is the slide for those of you who are asking that kind of the elements of capacity. And it could be, the mental capacity. The other thing to remember is, and we talked a little bit about, is that it could differ. I remember we had a case one time where the lady had a conservator in Ohio, a conservator. She was managing the money. The conservator got concerned because she wasn't realizing that she was running out of money. And the conservator was trying to convince her, with the money you have, it's probably better to go in a facility that's private, that has Medicaid certification, and it's better to go there now than wait till there's no money and be in a situation where you have no control over what facility you're going to go to. But this woman the client could not comprehend that they're running out of money. She actually brought it to the attention of the court and actually filed a motion. The conservator filed a motion to end the conservatorship because she felt that her client probably needed a guardian at this point. And it was interesting because we ended up having 2 evaluations done, one by a geriatrician who was in the clinic and one geriatrician who came out to her house. Both had different opinions. The physician in the clinic thought she had capacity. The one who assessed her in her home determined that she probably didn't have the capacity to function in that environment because she didn't have all the skill sets that were needed to be able to manipulate her home environment. And so this is an interesting case because she presented well at the clinic and they thought, yeah, this person is great. They have their soul, she was responding to the questions. She did pretty good with the mini mano because the other thing that came out was she actually had pretty good memory. It was her executive functioning that was impaired. And it wasn't until they did some testing on the executive functioning that they pick up the decline. So in that case, do you think she was adjudicated with 2 different opinions? How do you think they made a decision? No takers on that one?
Nothing yet.
Well, because it was interesting because I was actually called to testify. Oh, I got someone.
I was going to say they would have to call in another party, to mediate in between to make another decision. I don't.
Well, that's not they could have done that. The magistrate could have, if there was, remember, there's other evidence too, because there's the attorney. So there was the victim was a witness. The attorney was a witness. There was other evidence besides these 2 statements that the judge used to make the decision. But I was asked to testify, and so my staff thought that the most recent statement was probably accurate. So they're like, well, she has capacity. And so what I said to the magistrate, I said, when I testified, I said, you have 2 experts evaluating her. If her goal was to stay at home, to me, the expert who actually evaluated her in her home and evaluated her ability to manipulate think about it when you're house, when all the steps that you have to take in the morning when you're getting ready, and then all the steps you have to do to maintain your home. If he felt that she didn't have the capacity to manage your home, I think that we have to pay attention to the person and the expert who evaluated that this is what she wants, but they're thinking that she has a serious deficit there. So they didn't ask a third party to come involved because, like I said, they evaluated all the other evidence. But the guardian did what I thought was a good idea. The guardian was appointed over her assets and of person. The guardian, we're going to talk more about, she actually found out more about what our client wanted and figure out a way for her to live longer in her home because they pursued a reverse mortgage and it freed up some monies. So she was able to stay where she wanted longer because they were able to find the monies through the reverse mortgage to do that. And we're going to talk more about decision-making and some of the values in terms of making decisions.
So just 2 comments in the chat. I didn't want to interrupt you. One,
sure.
Terry put flip a coin ? And then Phyllis indicated her answer would have been err on the side of independence competence, which it kind of sounded like the independence argument sort of won the day, huh?
Well, they adjudicated her. So they erred on the side of the doctor who went to her home and had a strong opinion about why they felt she didn't have the capacity and ability to function in her home. So she was actually adjudicated based
Oh.
on the evidence that the home care doctor provided, who assessed her capacity to manage and manipulate and master her home environment. The guardian kind of, I thought, was the equalizer where she was adjudicated, but then she worked with her ward and made decisions based on her value system and actually helped her stay where she wanted to be longer. So I don't think guardianship is the end of the world. I know some people do. I think a good guardian appreciates their responsibility, but also recognizes and incorporates the adult who's being adjudicated as much as possible in decision making. I'm more of a fan right now of supportive decision making. So getting people evaluated is really critical, and it's not because I want everybody declared incompetent. As a social worker, one of my value system is I want to know. I don't want to assume anything about my clients. I want to know. Typically, a good evaluation is going to give you a good indication of what's wrong, what are the areas that need help, as well as are they treatable? Because some of our older adults, sometimes they end up in trouble because they're malnourished or they have a UTI or they're losing weight because they don't have the ability to manage that. And so providing them some support where they're eating regularly and they're getting their medications can actually boost their mental status and actually be more lucid and have the ability to interact more with other people. So I'm a big fan of evaluations. I know that this is an area in Ohio where it depends where you live. Not everybody has access to good geriatric medicine. Up here in Northern Ohio, we do. You guys have a luxury. Because I work for the Attorney General, not every county has it. And sometimes I tell folks it's worth driving for, to get someone to really it's an expertise. Not because the family doctor may or may not have this skill set. Most family doctors don't, but that's usually who you start with. I know when I was in adult protective services, sometimes the family doctor would tell us someone was competent, and then I would ask them questions about, well, have they been able to evaluate the patient? And then I find out they haven't even been trained in how to do an evaluation. And it's like, well, can we make a referral to someone who can? But again, as I know, I'm skewed. I believe in them. And not all family doctors are good with older adults. It does take some passion and interest to do that. So when we look at capacity, typically we're looking at it we're looking at these four things. So do they have the ability to make the decision? And you'll see that's, and then what decisions have to be made, because some decisions are critical, some are not. And then the situation when I was like, the case that I was talking about, that lady wanted to stay in her home, what resources were available? Well, private duty help costs money. If she was running out of money, I think they were concerned that, yeah, would she have the resources to stay at home? If she had waited until she ran out of money, she would not be able to have private duty help at the house. She would end up with very limited resources and would have been moved in a crisis situation out of her home. And then, of course, the level of risk. And I tell that to people all the time. What's going on? Can you tolerate the behavior? Can you tolerate the risk? So I do respect people's right to self-determine. And if it's like, if I'm a diabetic and I'm not following my diet, my sugar level might go up. You might want to give me a lecture and maybe want to send me to talk to a nutritionist so I can learn more about managing my diabetes. But you're probably not going to question my ability to care for myself and whether I need a guardian. I'm a diabetic and I have vision loss and I'm supposed to draw my insulin and I can't see the bottle. So one day I might give myself 10 units, the next day I might give myself 20. That's a very risky behavior and very harmful and can lead to very serious harm. So if I can't get that person to understand that the risk involved of drawing whatever insulin they want every day, that's where I'm going to probably start looking at, okay, have they been evaluated? Because we probably need to know if are they understanding the consequences of their decision, and do they know that they're putting themselves at risk? I'm going to want an expert to help me figure that out. Does that make sense? So it's really based on the risk. So it's not just what they're doing, what's the outcome of that behavior and what kind of risk does it pose and how likely are they to get harmed? So particularly looking at the ability to perform tasks, and this is where it's important, because if you look at all the decisions that you make every day, and some of you have spoken with folks, this is like, I had an example where the other day we had a case, was consulted on an APS case where the person is continuing to communicate with scammers, and they're giving money away. And she's like, we've spoken to him, but he keeps doing it. So I said to her, well, if you've gone out there and you've tried to educate him and he's still doing it, there's a certain point where we have to start wondering, is he not following through because he's in denial? Because sometimes victims will be in denial. So are they in denial, or are they not understanding what you're saying? And so that's why they keep doing the behavior. So it's like, we probably would recommend highly to get them evaluated. And that's what I was saying, because we were trying to separate. That's my big thing. When we're working with victims, we want to try to educate them to see if they follow through, or do we, if that's not working, we have to figure out what's going on. Is it because they're in denial, or is it because something's going on where they're having some kind of decline? So older folks can be harmed in multiple ways. Sometimes it's by accident. Sometimes it's someone who's very intentional. And this question actually came up this morning, and I'm like, well, how do you know the difference? And I'm like, you don't. I said, you basically find out when you're working with a caregiver, caretaker. Sometimes I call them perpetrators. I figure out, first I try to solve the problem by offering them resources. And then if they accept the resources, that's good, because that means that it was unintentional. Now they've been giving some information, and now they're going to do new behavior and make better decisions. I typically realize I'm dealing with a perpetrator when I do those things and they're not responding. I start thinking, okay, I'm dealing with an intentional perpetrator who's trying to manipulate the situation and control the situation. And I start switching, my head starts switching from someone who's unintended to perhaps this is a perpetrator who's trying to be very intentional. So again, this is a slide we actually kind of talked a little bit about it, but when we're trying to get them, can the person assess risk? Yes. I thought I heard someone wanting to have a question.
There's a question, but I think I'll wait till this little section's over and ask it.
Okay. But when I talk to my victims, I'm sorry, but victims for me has a terminology. I know some of you don't like that, but in legal terms, the term victim means something. But when I talk to them, I want to know do they have insight on what's going on? And by providing them the information, like I told you about the lady with the car, after we spoke with her, we realized that she was lied to because she knew exactly. And that's why I mean, would you have given the 10,000 if you knew it was for the truck? She said no. Sometimes the person doesn't know, because in having that conversation, can I win them over? Can I educate them? Otherwise, am I dealing with a willing victim, or am I dealing with someone who probably is being taken advantage of? So I'm going to want to get that evaluation to find out what I'm dealing with. Sarah, what was the question? Sue, what's the question?
So there were two actually. Gay had asked earlier, what if they don't have the capacity to make the decision? I think you may be getting there. The other one was, what about the person who acknowledges they're in danger, for example, of not taking their medications, but refuse support?
Well, and this is where they have the right to do that. So if are they refusing? This is where I remember we had a case where it was a case of she had to go to dialysis and she didn't want to go anymore. And all of you know what happens when you don't go to dialysis. You're basically choosing a very, very terrible death. So, because you get full of fluid and stuff. So we end up, I call it due diligence, before we agreed that she had capacity and she knew what she was doing, because of her decision was actually life and death, we did reach out to get her evaluated, because we wanted to make sure that she understood what that decision, what the outcome was going to be, even though she appeared to have, she's told us I just didn't go at face value because it was such a severe outcome. We actually had an expert help us make that decision. Not only that, in the process, sometimes if people want palliative care, that's fine. And so if that was what they were deciding, she had the ability to make that decision, we would have supported that decision and probably offered her services that would, like palliative care, that would make that decision more palatable. Does that answer the question?
It kind of does. So like, this is like an ongoing question. So like I work in a resource center. So I often get calls from family who they either have someone that has like a mental illness that refuses to take medicine, but doesn't go to actually get a diagnosis, has other health concerns. And the family is just like torn up about, they want to keep the person safe, but they don't want to take the medication. They don't want the medical interventions. They don't want, the family members' support. I had a call even just this week where the woman, her brother, who has actually like been in shelters, who she's discharging from the hospital home, but she's very concerned that, is he going to take medication? Does he understand how serious it is?
So that's so those are all tricky cases, because first of all, so family members just called me all the time as well. And so the first question I ask is, are they aware that the call is being made? Because technically they're the ones who'd be reaching out or asking for help. If it's someone else, it's very difficult for a third party person to make a call to a voluntary program. And even mental health believes in consumers having the right to make choices and recovery. And for civil commitment to occur, there has to be a very high level going on, whether it's suicidal, homicidal, or harm to self. And unfortunately, in some of these situations, the family can bring it to our attention, but it's going to require us to wait for a crisis to be able to interact or force services. If the person you're talking about is over 60, and I don't know if they are, but I don't know if and we'll talk more about APS. I don't know if a report to Adult Protective Services has been considered or not. The way the law is written in Ohio, the person has to be at least 60 years old, and they have to live in the community, and there has to be impairments that are either physical or mental that prevent their ability to take care of themselves. And so sometimes referral to APS is necessary when we think someone is harming themselves. And then we'll talk more about that too. But it's very, very hard to help someone else. And sometimes we have to explain to people about people's rights and people having right to self-determine and civil rights. Or I ask questions about whether they think there's capacity issues, because maybe there is a window there that we need to explore. So in Ohio law, in APS, for instance, Adult Protective Services, there's a lot of civil rights throughout the whole process. So people who want services and they've been, there's been an investigation in any protective services, it's offered. But that last sentence is very important. The person can withdraw at any point, and that can happen. So calling Adult Protective Services creates an opportunity, but it doesn't guarantee that this will stop, because if the case is screened in, for instance, whether or not the adult wants help or not will affect what happens next. And maybe they let me in the door in the beginning, but they can withdraw consent at any time. So it kind of makes things complicated. An incapacitated person, for the ones who want a definition, in the ORC, Adult Protective Services is in 501.60 through 0.74. And but basically, for APS to become involved, whether they're competent or not shouldn't matter. As a matter of fact, I think that's one reason why cases do not get reported, because we think, oh, they're adult, they're making this decision. As a mandatory reporter, it does not say in the APS law, if you think your person's competent, you don't have to make the referral. What the law says is that if you believe someone is 60 and they have some vulnerabilities and they live in the community, if you believe that they're harming themselves, then, and you have reasonable suspicions, you make the report. The capacity plays in, if I screen the case in, when I knock on the door, do they let me in? Because I can't do an investigation if they don't let me in. But if in the course of my investigation, I see signs that I think this person is having a hard time, and it's for any reason. So if the person is has suffered emotional trauma or trauma, you know, some folks with trauma-informed care principles, if somebody isn't making decisions and they appear not to make it, I suspect they may not be incapacitated as an APS worker. That's the first step of maybe I'm going to pursue a non-voluntary interaction or intervention with probate court. And we're going to talk more about it. Reasonable decisions this is one of the things why I believe in collaborations and team meetings and stuff, because again, what decisions are we not making? Well, how do they impact the person's life? What kind of risks do they pose? Like, for instance, we all know some medications they're not life-threatening. If I don't take certain medication, it might affect my health, but it's not going to kill me, versus other medications, for instance, Coumadin or Dilantin. There's some medications where have therapeutic value. So if I'm not taking it correctly, I can put myself at a higher risk. So this is one of the reasons I like collaborations and talking things out, because to get a better sense of what's really the risk here. In Cuyahoga, I was a chief supervisor for 10 years, and we had, and they still to this day have a interdisciplinary team, and there's a couple of physicians on there. When we talk about cases, sometimes they remind us about what decisions they're not making and reminding us, are you to look at the risk? Because are we going to tolerate it? Is it something that's not perfect, but it's okay? Or are these decisions going to be life-threatening and can cause great harm? Is when you're going to probably start looking at erring on the side of questioning their capacity and maybe getting them to go to see the doctor, or maybe forcing them. So the emergency is important. I remember I learned this one quickly. Emergency for APS, for those of you who don't know, when you call in a case, if it's an emergency, Adult Protective Services by law has 24 hours to open up the case, to go out and try to do an investigation. If it's considered a non-emergency, it's a 72 hours. But emergency also can affect whether, if I'm going to take court action, I need to be able to tell the judge why I believe this is an emergency. And is an immediate harm versus something that if I don't take action can affect the client, and we're going to, and maybe they're going to have more time to prepare for a case, because maybe I'm just going to get a general order, and I'll explain more of that in a second. So here's the title, or the definition for incompetency. So to answer your question, there's really not a definition for competent. There's a definition for incompetent. And an incompetent means any person who is so mentally impaired as a result of a mental or physical illness or disability or mental retardation. So you know this definition is old because we don't use that terminology anymore. As a result of chronic substance abuse, that the person is incapable of taking proper care of their person's self or property, and fails to provide for the person's family or persons of whom the person is charged with. This is what the judge is looking at. So when we're presenting a case in court and we believe someone is incompetent, we have to have clear and convincing evidence is presented. So it's not just a statement of expert evaluation. It could be witnesses, it could be professionals. If the person's had a physical therapy evaluation or an occupational therapy evaluation, if there's been any type of evaluation, they might be called in to testify. We would need to show proof that they're not able to care for themselves, or if they're not able to take care of their property, because that might be a guardian of a state. But this is the definition of what Ohio considers to be a definition for incompetent. So again, everyone's competent. So that's when someone tells me, oh, they're competent. I'm like, yeah, I know that. Unless you know they've been in front of a judge or a magistrate in probate court, then everyone's competent. Whether they have mental health, dementia, we're all competent unless we're actually in front of a judge and it's been determined otherwise. What in most situations I'm guessing is you're mostly questioning whether or not they have capacity issues that could lead to being determined incompetent. So surrogates, there's all kinds of different surrogates, whether it's mental health. Some of you might have power of attorneys. Some of you may have granted power of attorneys to some of your family members. So there's different levels of surrogates, and basically it's giving someone else the proxy to make decisions for you. Here's another one that most of you probably know. Most of us don't do this ahead of time, which I preach. We probably should take the time to decide and make decisions while we still have the ability to make decisions. But most of us don't. There's an emergency and all of a sudden you're in a hospital and someone's asking, is there a healthcare power of attorney? I mean, it's common that we wait for a crisis. But most of these, and what I want to point out is that typically when there's a legal surrogate, the person has to be, the person who's executing it needs to understand the contract for it to be executed properly. And when I was in APS, we used to call power of attorney's license to steal, because too often you can download one from the internet and have somebody witness it. It was very easy to for a bad perpetrator to get a power of attorney executed, while at the same time I'm questioning capacity. I'm actually thinking about looking at guardianship, but they're trying to execute a power of attorney. It's many of those times it's too late. It's improperly executed, because technically the person needs to understand that's what's going on and picking who they're giving the decision making to. So the daughter can't choose to be the power of attorney. Mom has to decide it, and she decides who she gives it to. It's a red flag. If a family member says that, then the next conversation should be with the adult to try to figure out, because it's got to be their decision, not the family members. And good surrogates, it's a hard job. Those of you who have been in this position, there's having authority to do something and then acknowledging and respecting the authority you have is important. Because I think a good surrogate tries to involve the person you're making decisions as much as possible, and you want to recognize them as much as possible. It's clearly difficult to make good decisions sometimes on their behalf if you don't know them. Like when I was in APS, when we got a protective service order, I didn't know that much about my individuals. I had to rely on the doctors and different tests in terms of trying to make decisions based on information that's being provided for me, because I didn't necessarily know what they would have chosen. But this slide, we're going to talk a little bit, wills and declaration. So the things on the left on their list restrictive, most of the times in all those situations, the adult is still assumed to have capacity and they're still competent. So exercising wills, wanting to do with your money, a durable power of attorney, a power of attorney conservator, even a conservatorship. I still have someone who has capacity. I'm still considered legally competent. I'm very much involved in who's going to be making decisions for me. Most restrictive, adult protective services, and it's unique to adult protective services, they have the ability and the responsibility to petition the court for an order, or civil commitment or guardianship. In those situations, the individuals starts going from an incapacitated person. So protective services cannot pursue an order unless we have evidence that this person is most likely incapacitated. Could be a doctor making that recommendation. So I know when I was there, I didn't know, we had pictures, we had witnesses, we had neighbors, we had multiple cases being called in. We had all kinds of evidence for us to suspect someone was incapacitated. At the hearing, sometimes what we wanted and what we wanted the judge to grant us was the order to have the person evaluated, because I needed to find out by a professional whether this person had capacity or if they were incapacitated, and sometimes whether or not we should be pursuing guardianship because it was advanced. So what I liked about protective service orders is that they were temporary. It gives you an opportunity to put it in service plan that hopefully can stop the abuse, neglect, or exploitation. But and they expire. The bad part is that they expired. So after the fact they expired, what is my plan? I needed to have an idea what's going to happen next, because the orders there's 3 different orders. The routine is usually 6 months and the level of threat is lower. And then the emergency, the hearing was going to take place within 3 days. So I had to have the case pretty much tidied up before we went to court. And then the ex parte is when you basically have the hearing after the fact. Basically, APS contacts their attorney and they discuss the case. The attorney ends up contacting the judge directly. They grant it, because ex parte means it is life-threatening. And if we don't take action right away, the person can die. But they still have a hearing, but it's after the fact, which the case is reviewed. So in all the APS protective law, there's a lot of respect for the adults' rights, and they have the right to be present. They have the right to have an attorney. None of this is done behind their back, which is very different from civil commitment. Those of you that have been involved in a civil commitment, typically you can go down, anyone can go down to probate court and tell the magistrate why you think someone might have mental illness and it's in a crisis. They can give you an order, but the individual doesn't get a chance to be present until they get taken to the ER, where they're evaluated as whether or not they're going to go to get evaluated for 72 hours. So this is just another slide that kind of reminds you that there's different types of guardians from a person. So in Ohio, we recognize an estate as having more than $25,000. So like veteran that I was telling you about, he couldn't manage his money, Social Security checks, pension checks, income, that's typically handled under guardian of person. Estate is typically when the assets exceed 25,000, and then sometimes you can have one or the other or both. Limited guardianship is when which is what we ended up doing for this individual. He was granted a guardianship over the finances. He was still allowed to manage his person. Interim, that's exactly what it sounds like. I have maybe the guardian, sometimes we can't find an applicant, so there's a temporary guardian appointed as an interim while we're looking for a replacement. We don't use emergency guardianship in Ohio too much because it literally is only 72 hours. And it's a lot of resources. Those are usually used when there's a medical decision and you need someone, someone got hit by a truck and now they're unconscious. They didn't have a power of attorney. They don't have a surrogate. So we're going to try to get a guardian in place. But typically guardianships last for a while. You can undo it, but it's just another court hearing where you have to undo. You have to prove if they've been adjudicated incompetent, the next hearing is the opposite. You have to prove that now they have capacity. So you have to provide medical evidence that they can't take care of themselves, but it's another hearing. Very rare, but it does happen. The role of probate court is important because they're the superior guardian. So, and so when we had cases, we typically notified the court right away that an APS case came in and there was a guardian appointment. Because one of the things we need to look at, it was a guardian not doing their job or not providing enough care. So sometimes an APS report triggers a motion at probate court to review the appointment. Reasonable decision, I think we kind of talked about why we would want it. Usually we need a surrogate because there's decisions. Somebody needs to make a decision that isn't being made or they can't be made. And so that's why you're looking for a surrogate. Sue, any questions or just keep going?
Sorry, I was on mute. There was a comment earlier from Marcus about caregivers and whether there was anybody who was checking like a family members who are caregivers, and whether or not there's any checks on those family members and the sort of quality of care that they're giving.
So that's it depends, because if they're connected to an agency, a case manager, sometimes I know, for instance, in the Passport program allows for family members to be caregivers. Actually, and they sometimes pay for it. But so if they're set up with a case manager, sure. Otherwise, it's up to when they go see the doctor or whether they, somebody else comes in for an appointment and you might have questions about what's going on at home because they look disheveled or they're not looking like they're taking their meds, or they're frequently visiting the ER. Some of you who work in ER might pick up on that because they're using you more than they should. So unless they're connected to a formal system, I would probably say it would be up to all of us when we interface with them to be that person to check on them. So this is a slide that I like because it reminds us that everybody's unique, and so surrogates need to be paying attention to making sure that the decisions they're making are as close as possible and consistent with the value system of the individual you're making decisions for. So substitute judgment is a phrase that's used. I know the person very well, like my parents. I knew my parents very well and was able to, because I knew them and I knew what their decisions would be, I found myself making decisions that I thought they would make if they could. That's what we use the term substitute judgment. Best interest, and sometimes you use both, because if my dad was a diabetic and he wanted things that were bad for him, I probably wouldn't let him have it. So best interest is when you follow the guidance, because typically, like when I was in Adult Protective Services, I relied on best interest quite a bit. What are the doctors, what are they recommending for the person? Do they need to go to rehab for skilled care? It would be better to do it at this facility because it's very high intensive versus home care. So I relied very heavily on someone else giving me guidance as what was in the best interest of the individual. And again, sometimes you kind of combine both. Some of you are probably parents. When your kid wants to go to bed and wants dessert, you may, it's the best interest not to let them eat candy or sweets before they go to bed. So you find yourself trying to balance that. It's the same thing when you're a surrogate. The shortfall of surrogacy is, I think I mentioned this already, but this slide kind of covers it. If you don't know the person, it's hard to know what their preferences would be. So you kind of just have to, that to me or they're different from you. Sometimes they have religious, but that to me is one of the complications. So what's obviously talking solutions to the problem is pre-planning. Some of you are working with adults right now, having or even your own family members. I remember sitting my parents down and having this conversation because I knew that as they got older, they were going to need someone to help make decisions. And matter of fact, my parents decided that they wanted me to have power of attorney because they're like, if we go into the hospital, we are going to be sick. And if we're sick, we're not going to be able to make good decisions. And they were first generation. I'm a first generation Cuban American. They were from Havana, Cuba. They spoke Spanish. They're like, and we're going to have a hard time. So when we drafted our paperwork, they actually wanted me to make sure I can make decisions for them without having the qualifier of them being incapacitated. Most power of attorneys, though, don't go into effect. There's typically language in the power of attorney that says they go into effect when we have more information of the person being incapacitated. And that's important because sometimes we think if somebody's a power of attorney, it's automatic. You do have to read them because that's not usually the case. Typically, power of attorneys go into effect when we have the person, for whatever reason, is incapacitated. Was there a question? I thought I heard it. I thought I heard something.
Nope.
Okay, so a little bit about APS. This is a review for some of you. Here's a good question that I can put in the chat. Does APS have the jurisdiction to remove an older adult from their residence in order to reduce or eliminate the exploitation?
Terry says no.
Do they have the jurisdiction? So
Lauren
Terry
says no. Lauren says no.
This is a bit of a trick question. They technically, so they can't remove people from their home, but they can, through the law, they are the only, it's very specific in the ORC, they can petition the court. So it's actually the judge who can remove you from your home if I present enough evidence in a hearing that you need to be in a facility and I have everything to back it up. The judge might agree with me and order the person to be placed in the facility. So by themselves, they don't. The teeth of APS is actually probate court. So in the APS law, we basically investigate abuse, neglect, and exploitation. We make a lot of referrals. So it's not a criminal investigation. Some folks think, so my job is not to put somebody in jail. My job is to provide protective services. If I need someone put in jail, I'm going to want to work with the police and get them involved. The second part there is important. Departments may petition the court. So it's unique to APS. It's in the ORC, where if we believe we have someone who's incapacitated, they're experiencing abuse. So it's typically after I've investigated a case, not at intake. When you call me, it's alleged. It's after the investigation. And we've tried to resolve the problem. We've tried to connect. We don't have a decision maker. There's a lack of ability, or there just hasn't been anyone. And we have to have a validated case, meaning they need protection and they're refusing. I have to have all that in place when I present that in court to determine if there's enough evidence it's granted. So these are the different types of abuse that we recognize here in Ohio. Abandonment is actually the newest allegation that was added, and that's when someone literally leaves someone without care. And so, and I'm glad they added that, actually, because sometimes before it was added, people would call, the daughter left town. It's like, well, there was no legal reason for her binding her to be the caregiver. Abandonment is a good addition to being able to screen that case in and take a look and do some resources. So there is a duty to report in Ohio. And this is important too for you to recognize that it's basically, when you're making the report, you just have to have reasonable suspicion. Sometimes people think they need proof. No, someone's missing doctor's appointments or losing weight. They're missing, they're missing their appointments, are not coming in on time. When they do come in, they look disheveled, they don't look right. You just have to suspect it, and they're going to ask you why you suspect it. And if you do suspect it, you're supposed to immediately report it. And then the investigation is where we figure out what's actually going on.
So there's a comment. I'll just go ahead and Terrence wrote in, sexual abuse should include inappropriate or unwarranted touch.
Yes, absolutely. And this is what I want you to know, that there's a new law that's being effective April 4th in 2023. So it's been signed by the governor. It'll be enacted. The failure to report knowingly failing to report elder abuse, knowingly, so so it could end in, they made it parallel to Child Protective Services. So now the penalty could be a 4th degree misdemeanor. And right now, how it stands, and failure to report could have ended into a fine of $500, but this is going into effect very soon. Some of you, I don't have a lot of time, so I didn't go into the nuance of mandatory reporting, but mandatory reporting in Ohio, we have a very, very extensive list of mandatory reporters. It was expanded in 2018, and there's probably over 30 professions that are now mandatory reporter, including notary republics was one of the new ones, the banking industry, the financial industry, CPAs, the ambulance driver, because I can't believe they weren't talking about someone, or the ambulance driver, as well as the paramedics are new. So there's a lot of new mandatory reporters, and there's a lot of training being requested, because many of us who are mandatory reporter probably never received any training around what am I looking at and what am I reporting. So I think if you are interested in having a follow-up to this that goes into the more specifics of mandatory reporting, I'd be happy to do that. So the Ohio has different ways for you to report. Typically, the more information you have, the better. So the age is important. Ohio is age 60, so not 59 and a half. It's in the ORC, it's 60. It's based on that. The vulnerabilities are also important. So not so much medical diagnoses, but how and what are some of the concerns you have as to why this person can't take care of themselves? Because the way Ohio, it's not just age-based, where they're saying the person has to be suffering from some type of vulnerabilities to prevent them from being able to take care of themselves. Otherwise, it's your civil it's your civil right to take care of yourself and make your own choices. So typically, weight loss, memory issues, I mean, it's not too hard to meet it. Like if you're having a conversation with someone and they don't think like they appear to comprehend what you're saying, they don't remember you from one appointment to the other. So and if you need help with that, my contact information is at the end. Sometimes people call me wanting the Elder Justice Unit kind of sort out, is this the case? Do you think this is meeting the criteria? We kind of help you with that if you want some help. You don't need to have, so it's not required to have the name of the perpetrator. You may or may not know that. They may not have a perpetrator. Someone's self-neglecting. It's because you're concerned about their own ability to provide care.
So I wanted to ask specifically about that. So self-neglect is one of the things that you are a mandatory reporter on too?
Yes. And that's probably, neglect and self-neglect probably comprise over half the reports that are reported. And self-neglect cases are probably the most difficult because typically the self-neglect, sometimes it's a lifestyle choice. This is how they live. But I would say typically some of those folks, as they get older, will become a victim of their choices. And so it becomes obvious, they develop other comorbidities. But those cases are hard because they gonna need do they want help? And if not, do I have enough evidence to get a protective service order? So sometimes I need to have a case come in multiple times to collect enough evidence, because so those cases are the most challenging, and those probably the most times that you call those in and then you get frustrated because I called APS and nothing happened. Well, did they let me in the door? Because if they didn't let me in the door, I'm not going to be able to investigate. But maybe they let me in the door the first time, but then they didn't the second time, because then by the second visit, they know what I want. So the APS law allows them to withdraw at any time. I can only keep going. If they say no, I have to stop unless I have enough evidence to approach probate court. But that's why sometimes people call me, because we just kind of consult do we have it? But there is a hotline and that number there. So if you're not sure what APS you're supposed to be calling, in Ohio, Adult Protective Services follows the body. So if the person lives in Summit County, you're going to want to make the report in Summit County. But if they're in a hospital in another county, sometimes it's generated when they're in the hospital. So sometimes you open up a case in one county, but it's going to be transferred to the county where they live. It's a little complicated there, and that's where. And then the last thing that they created is a portal. So some of you have jobs that aren't 9 to 5. The portal allows you to make a report online, and it'll ask you some questions about the case, and then it'll take it to the county they live in. And so the response time I kind of mentioned, but just for your slide, that typically if they accept the case, it's within 24 hours. Otherwise, it's 3 days. Typically, once the case is reported, we have 30 days to do an investigation. And so the investigation should be a face-to-face contact with the individual. The referent, it says consult with the referent is feasible, because technically the Ohio law allows you to make an anonymous report. I don't recommend it, because if you do make an anonymous report, you won't be able to get any more information about it. But and by the way, when you make a report, the only thing they're allowed to tell you, because APS records are confidential, they're not public, is they can tell you if the case is screened in or not. So I would highly recommend when you make a report, ask them, are you screening the case in? The way the Jobs and Family Services says, they may or may not tell you, but I would ask, because if they don't tell you. The last thing that we do have to provide the individual is an intent to investigate. So the reporter's identity is never given out, but sometimes the report is very specific. So if I'm in a bank and my daughter yells at me and slaps me in front of the teller, she might make a report, but it's going to be a very specific incident. It's going to be easier for them to find out who made the report. But I assure you, APS does not tell the person who made the report. That information is confidential, and even if it's subpoenaed, the identity of the reporter is never disclosed. Putting plans together, we do follow least restrictive, so our goal is to try to keep people in the community as long as possible. we go through, a lot of you might be some of the services that we use, but getting people connected to healthcare, home care services, home delivered meals. So we come up with a plan that's least restrictive, that's going to meet the need of the allegation. But if we're sticking you in a nursing home, first of all, you have to meet level of care. Who's paying? Is it Medicaid, private pay? I don't have a magic wand that can bypass all that. APS has to deal with a medical necessity and everything else that everybody else does to try to get information from the medical field.
So Marcus has a question about
Sure.
Training as a mandatory reporter. Is there, where might he find that?
So I can send Sue, you can send it out to everyone. There's the way that ORC is written, Jobs and Family Services is required to provide resources. So they do provide a guide. In the past I've given it, I can give it to you again.
Okay.
So you can request it from your own local county adult protective services. So they do, each county has their own APS, and a lot of them will take requests to go out and do a staff meeting and training upon request. My office does a ton of it. So I get asked often to go out and talk but it's available, and I'll send you that information so you can share it with your folks.
Great. And then we have another question about the capacity of APS to really respond to all of these, given the sort of the upping the number of and the increase in penalties associated with not reporting. Does APS have the capacity to screen all the cases?
And that's a great question, and that's going to depend. So Ohio has a state supervised county administered program. And unfortunately, right now, the funding to APS is very limited. It's flat funded, which is one of the few organizations that does it. So this is where you can be helpful and talk to your legislators, because we need to continue to fund the program. Right now, the state of Ohio provides each county, I'm glad you're sitting down, because if you weren't, you'd fall off your chair, $65,000 per county. 65, which is not a lot. So one of the reasons why you experience such difference from county to county is how are they funding their program? Do they have a senior levy? Do they have other resources? Are they using Title $20? So in Ohio, we have a lot of different ways, and most programs are very different. It's because of that. The biggest issue right now is not the law; it has to do with the funding. This is why it's important for you to get to know your county's APS and have a relationship with them. Each county does have an interdisciplinary team. So some of you might already be a member of your I-team, but it's a great place to get to know your APS staff and be a service to them and be their partner. And I'm a big fan of collaborating with other entities. APS workers aren't necessarily mental health workers, but they have to know about mental health. They're not medical social workers, but they have to know about conditions that pose a threat. So I might not have the knowledge, but maybe you do. So working together is critical. And maybe you can teach me that something is life-threatening. I know what I know. I'm a social worker. I know what I know because of working with folks who taught me, working side by side, the doctors and social workers. And so and mental health workers, domestic violence. And at this point, I've been doing it for a while. So but I'm a social worker. I'm not a medical social worker. And so you might know something that's important that could be helpful to APS to understand why something is bad. Hopefully I answered your question, Sue.
Yeah, Terry had a comment, and I'm not sure, Terry, what it was referencing.
You said that you have $60,000. I said, does that include all your paychecks?
65. 65 is not very much.
Yeah, that's terrible.
It's terrible. And if the legislation right now, we've asked for another. So I'm also a board member of OCAS, which is the Ohio Coalition for Adult Protective Services, and we advocate for more funding. And we met with the director, Matt Damschroeder. For the first time ever, they're asking for more money, because typically it's us asking legislators, they need more money. Why? But as Ohio has as a state is the 16th largest population of older adults. So Ohio is aging. We've done a bad job preparing for that. And people are dependent, if APS is a safety net, and helps people get and restored safety, we probably need to invest a little bit more in that. But if the budget passes, I think it's going to go up to 85,000. So I can only tell you we're going in the right direction, but clearly there's a void there. And this is where I like to tell folks, talking to your legislator can be helpful, because they need to hear from the constituents and what the real problems are. But APS is going to need everyone, all hands on deck, talking to legislators as to why they need to invest in the program.
I have a question for you about one of my clients. He is schizophrenic, and he's very pleasant and everything, but he has very poor insight into his deficits. He also has a history of substance abuse. So he was in 2 different assisted livings, and he stopped paying his part, and he got evicted, and then he went to a nursing home and he eloped. And then, so I had called the ombudsman at that point, and she was trying to help me. He became homeless and was living on the street. So I urged him to go to the hospital, and now he is in a nursing home for rehab. So he's going to be homeless again soon through his own doings. I don't know what I should do about him. Like, I don't know, maybe I should call the ombudsman at this point.
Well, if he's in the hospital, and maybe I would probably reach out to the staff there, because
Well,
I'm
he's
sure
in
there's,
the nursing home now.
okay, he's in a nursing home, but he's
Yeah.
he's rehabbing. He's there as a rehab patient.
It's not going to be long though, because he's highly independent.
It sounds like he needs a good evaluation, because how old is this guy?
He's only like 63.
So technically he's old enough to meet the statute of an adult in Ohio.
Mhm.
But so insight, so he would probably need a special evaluation, not just a memory like a mini mental, because his memory might be intact. It might be his executive functioning
Correct.
that's off. So
Yeah.
he probably would benefit from someone looking at his ability to make decisions and carry them out, because poor insight could lead to someone being incompetent if they're not, depending on what's going on,
Mhm.
and what kind of risk they pose. Being
Mhm.
homeless is an interesting problem, because in up north, being homeless in the wintertime is different than being homeless in the summertime.
Mhm.
But I would try to see while he's in the hospital, if you guys can have a care management team to see if you can do a discharge plan to try to see if he's able to make any decisions, or maybe while he's at the nursing home, if we can have him evaluated, because you might be able to find out more about what's going on. But schizophrenia, there's a new term that I've recently learned, and some of you might have heard of it: mild cognitive decline.
Mhm.
Our executive functioning is the last part of the brain to develop. That's why some of you have teenagers and they look like grown-ups and adults, and then you're like, how did they make these stupid decisions? Is because their executive functioning hasn't been totally developed. It's the first part of your brain that starts to declining. So sometimes you have a couple different things going on that add up to more. So mild cognitive decline, if it's happening on top of someone who has an pre-existing mental health like schizophrenia, it's possible that 2 things together can cause more problems than only having one thing. So decline of the intellect, it depends on what his IQ was to begin with.
Mhm.
And so that's why, again, an evaluation can establish a baseline, because if it comes back that he's able to make his own decisions, then that was your due diligence. He's still able to make poor choices, but
He calls me all the time asking for help. So I know that he knows he's not making right decisions, but he doesn't know how to fix it. And he's very bad at taking direction too.
which is probably why I think an evaluation of his executive functioning would help us figure out
Yeah,
if
I
there's.
referred him to psych at the nursing home, so maybe I could get him to do a full eval there.
It would be good to try to do that before he leaves, because
Yeah.
maybe you can figure out what's going on. In the nursing home as rehab, so the ombudsman is a good one, because right now he's a long-term care consumer. Technically, I don't know what county he's in. Adult Protective Services could technically get involved because he's a patient. He's not living there. He's not a resident.
Okay.
So maybe consulting with them as well might be an option. And if you want to, I know my contact information is available at the end. If you
Okay,
want to
cool.
take a deeper dive with me,
Yeah.
people, you know, like I said, people call me and we kind of consult, and sometimes I give them ideas, or at least I validate, yeah, there's no solution here, because Ohio has a lot of gaps.
Mhm.
And so sometimes we have to admit that, but then
Yeah.
we can prepare for the next opportunity if he
Mhm.
represents himself, but I'll be happy to talk to you more offline on that.
Okay, cool. Thank you so much.
You're welcome. So complications, we just discussed a complicated case, and because adults have rights and civil rights, and we start with that assumption, with older adults, we have to have proof to help someone who doesn't want to help. Requires us to have a lot of evidence to support why we would believe they can't make those decisions. The other complication with elder abuse cases is many of our clients, if it's their family member, that's a hard thing to say, my son or daughter is doing this to me. My son or daughter's hurting me. And so them coming forward is very difficult. There's also a lot of reluctancy because they don't want to get their loved one in trouble, or they don't want them to go to jail. They just want us to figure out how to stop it. So sometimes getting the person, the victim, to tell you what's going on, that's why it's so important to have a conversation with them by themselves and not in front of other people, to see if we can figure out what's going on and how we can help them and what system. So one of the advantages that you have with the elder justice system is that we're pretty good about understanding all of Ohio's systems. And so sometimes we have to figure out which system is in the best position to help. These are just a slide for you in terms of case considerations. When we want to go against someone's wishes, I mentioned this several times. It's just basically, you know, do we need more information? You know, what evidence is there? Where does the evidence exist? Where can we get it? So sometimes it's just, we need more information. That's why, again, evaluations are so important, because it gives us the information we need to really know what's going on. And it's based on that individual and not our assumptions of what we think might be competent or incompetent, but actually dealing with facts. And then what do we need to do? How are we going to restore safety? Can we educate this person? Can we provide the resources? And if they're refusing, quite frankly, I like to do that, because then it gives me evidence that we've asked them, we showed them, and they're still not picking the right thing. That becomes critical evidence in court. If I need a court order, that I can show that we took those steps, and now we need the court to intervene. So, that's just a slide reminding all of us that we want to engage with our older consumers, and I'd rather have you err on contacting APS than not, because I already know when I was a young social worker, we used to say 1 in 5 case was called in. Now we say 1 in 24. So I know there's a whole lot of stuff going on there that we're not recognizing. And again, I'm going to end with, we can't help them unless we recognize there's a problem. I'm going to open it up for questions. We just have a few more minutes.
I want to make sure. So Gay had asked a question earlier, and I kind of said, you would cover it. I want to make sure Gay got full answer to your question that you asked earlier about the difference between the competence and the capacity.
Yes, she answered it.
I
Thank
did.
you.
Well, thank you.
Yes.
Then you made that easy. They're connected. They're kissing cousins. Judge Swift told me that about 20 years ago, and it stuck with me. But there's my real phone number and my real email address. I think some of you in your work may come across. Do not hesitate to use this as a resource. And to reach the Elder Justice Unit, you can go through the helpline. It'll come to us. That's 800 number. What's nice about the AG's office, we have 33 sections, but one help center. That group directs the callers to where it needs to go. So families use this all the time, but we also get a fair amount of professionals. Ohio does have a very, very complicated elder justice system. When to call APS, when is it domestic violence, when is it both, when is it the police, maybe a crime occurred. It's hard, and that's why knowing when and how is complicated. And Sue, if you want me to come back at another point to do one specifically on mandatory reporting and roles and responsibility, because it's impossible to cover the whole thing in one day.
Sure. Yeah.
But you know how to find me, and then I'll send you an email later with the additional information that I already forgot. I was going to email you about
how to, the trainings was
Oh,
one.
yes. Yeah.
And so this is a great example, just to sort of close it out. I don't see any other, just thank yous are in the chat in case you don't
Thank you.
get to see them. But just a great example of, there was a lot of great information presented today, not meant for anybody to walk away and say, now I know everything I need to know, right?
Right.
More important takeaway is, sort of increased awareness of what the issues are and who you need to contact. And if anything, I think my takeaway is, you need to contact the experts to really just have that discussion, because it's, every case is probably ever so different. But
Yes.
Yeah.
One case, and
yeah,
these cases are very individualized. That's probably why I'm still doing the work and passionate, because one case of elder abuse, you might be able to apply it later, but typically there's so many nuances are related to that particular individual and what's going on in their life and what do they want. So I agree
Yep.
with you.
Yep. Just like so many other things with geriatrics, right? It's like, well, what services are they eligible for? Well, it depends on a whole lot of variables, right? So we just had a lecture on Medicare rules, and there are so many details that you have to know. So thank you very much.